can you help me on what the impact of those events and the impact of the circumstances in which the application was brought and heard should have on the way in which we adjudicate this case? Because in Kabushiani, the judgment wasn't moot at the time it was given. It was clearly a live issue. It became moot after the judgment, and this court then dealt with whether or not it should deal with that. In Pillay, have some knowledge of, the Constitutional Court set out 5 factors which would justify hearing an appeal. It had also become moot because the schoolgirl concerned had finished school, and it concerned her compliance with school rules. She'd finished school, she'd gone to university. Now, so it's a different factual situation. And if you looked at the 5 reasons the Constitutional Court gave, amongst them were the adequacy of the exploration of the facts, the adequacy of the exploration of the constitutional issues raised, and the like. Now, the fact we've been given all this additional evidence surely demonstrates that Justice Fabricius did not have an adequate set of facts before him, and indeed the latest affidavits that your client has provided from his medical records demonstrate that the factual foundation for the court's judgment is, shall we say, at the least unstable. So how do we factor all that into an adjudication and appeal, which, as my sister presiding has said, we have to deal with?
How I will submit this court should deal with the matter, and based on the Pillay analysis, would be first to concede that when the matter served before the protocol, the evidence, to say the least, was very thin, and that is hence we sought on appeal to bring various applications to address new evidence on appeal. If this court were to be inclined to admit that evidence, then the case we submit would fall within the Pillay analysis, in the sense that there would be adequate material before this court on the basis of which to determine the issue as it arises. And the fullness of argument, we would hope that this court would get assistance from the multiplicity of the parties that are before court to assist the court to determine the issue that arises. And we make that submission because of the public importance of the issue that arises in this appeal. And but then what remains...
I'm sorry to interrupt you at this stage. As I've indicated, you may argue as if the evidence, other than that of Dr. Cameron, has been admitted. The difficulty is, how do we consider any of the evidence without being able to properly evaluate it? There are multiple conflicting affidavits attaching multiple academic pieces on the entire issue, and there is a very, very large difference of opinion insofar as the kinds of order that Fabricius J. made. How do we deal with that evidence?
You see, in Carter's case, Justice Lynn Smith in British Columbia conducted a full trial. She had, I think, over 50 witnesses, some on affidavit, but others subjected to cross-examination. And she made factual findings which the Supreme Court of Canada held could not be overturned, although they were in fact attacked on appeal. But by contrast, in Seal's case, the New Zealand court had 30-odd witnesses. In Nicholson, the House of Lords, or the Supreme Court, had a massive evidence, which the inadequacy of which, in inapplicability of which was dealt with very lucidly by Lord Sumption. Now, how do we deal with it? We're just taking the simple facts about Mr. Stransham Ford. The affidavit is now filed placed all those facts in dispute. In fact, they even placed in dispute the question of whether he wanted physician-assisted suicide.
He was vacillated. He was vacillating at best on the evidence. He wasn't settled on whether he wanted to go ahead with it.
Thomas, did I understand your submission to be that, written on the authority of the lay, that there was an adequacy, canvassing of the fact? Because if that is so, it seems to me that the contrary appears when you simply look at what my brother Wallace has put to you, that when you consider the Carter case, the court had regard to the canvassed evidence from Canada and from numerous other permissive jurisdictions in relation to physician-assisted death, and it considered medical ethics and current end-of-life practices, the risks associated with assisted suicide, and the feasibility of safeguards. Now, none of that was before Fabricius came. To the contrary, it was an urgent application, where an order was made virtually a day or two after the application was heard, and the reasons were given in some days later. Now, on what basis conceivably can Pillay apply in relation to the adequacy of the facts?
Justice Kepers, I'm constrained to agree that although the parties tried to remediate that subsequently, it doesn't go far enough. And if the court feels itself not assisted by the subsequent evidence that has been put before it, then the matter has to be, the appeal has simply to be upheld on the basis that the matter was moot as at the time, because there were no personal rights, there were no rights in personam capable of vindication at the time of the granting of the order.
The difficulty with that submission is that, as I understood it, there is agreement that we cannot let that judgment stand as it is, and so the appeal must proceed, and it can't proceed on the basis of mootness. We have to set aside the question of mootness and proceed on the basis of what is before us and of what we do know about the nature of the relief sought, the factual position of Mr. Stransham Ford before his death, and the evidence of the doctors. We must proceed on that basis.
Justice Lewis, I must apologize. The first point that the justice made about an agreement, I didn't quite follow that, and I apologize profusely. Did the justice?
As I understood your approach and the approach of my colleagues, it is that despite the fact that the matter was moot even before it was heard by the Pretoria Court, despite that, the appeal must continue on the basis of what is before us.
There is no agreement between the parties that I'm aware of. There is no agreement between the parties.
No agreement between the parties, an agreement between your approach and that of the justices on the court. I'm not suggesting that there's an agreement insofar as the parties are concerned, not for a moment.
Yes. Well, all that I can add to that proposition, and I'm not sure, I'll be honest with you that I follow it completely, but my submission in that regard would be this court, if it finds itself not adequately assisted in the context of Pillay to hear the matter applying the Koboshiani principle, then the court must simply uphold the appeal and overturn the order of the court on the basis that it sought to vindicate rights, personal rights that had ceased to exist at 8:07 of that morning. So it was incompetent, the order was incompetent, and that's the one basis on which we will submit that it should be set aside. But then comes another basis, which is factual, and that is based on the Cameron affidavit, because it contradicts.
I think we're at cross purposes.
Oh, we are?
Yes.
Your client wants the decision as precedent set aside. You want it to have no precedential value,
yes,
which is why you want us to look at the merits of the decision and say those merits are wrong. That's the point which I think is being put to you.
Yes.
Even if it's moot, however we deal with it procedurally, you want us to go beyond that and say, look, the reasoning, the outcome is simply as a matter of law wrong. That's what your clients want.
Well, what our clients want is to overturn the decision of the court of court.
Yes.
The court does not have to go so far as to declare whether the impugned common law rule is unconstitutional. If the court finds itself, if the court is of the view that it does not have enough in the way of evidence, in the way of argument, to reach that conclusion, the court does not have to get there. We will be satisfied with an order that simply overturns the decision of the court of court, one, because it was moot, and two, because it's not supported by the factual basis that was on which it was made. Trust me, I understood the question. I hope I've addressed it. Justice Lewis.
Yes, I still don't fully understand whether you want to proceed on the substantive issues of arguing that, first, it is not the court's role to make such a decision. It is not for the court to change the common law in this particular way. I had thought that that was one of the arguments you were going to raise, the separation of powers issue. I propose that we still deal with those issues.
Perhaps you could address us on the factual issues and then go on to the law.
The rights sought to be vindicated, beg your pardon, by the late Strachan-Ford set out on page 11, volume 1 of the appeal record, and those are 9.1.1, human dignity, 9.1.2, not to be treated in a cruel, inhuman, and degrading way, and 9.1.3, an infraction of his right to bodily and psychological integrity is being relied upon. The facts that the late Strachan-Ford put up in support of that allegation occur from page 27.
Yes, we have the record and we have read it. Perhaps you could just address your argument to the facts that you assume we know.
But what I will do so justice, may I just highlight what I've considered to be important so as to anchor my argument. What he alleges is that the imminent future, as he sets it out from paragraph 25 and further, he says that he is going to suffer from intractable pain, and that's the reason why he sought the order in the form of a declarator. He then says at paragraph 30 that as the disease progresses, I will be confused and scared until I breathe my last breath, which may even be with a machine. He then deals with dignity, paragraph 33 and further, and he then says that there's no dignity in general terms, all the way to page 30, from dying, having pain all over his body, being dulled, his senses being dulled, being unable to take care of his own hygiene, and dying in a hospital. All of those issues, those allegations he makes in support of his allegation, as it were, that he wants to die with dignity. He then expresses what we call a death wish at paragraph 35, says that he wants to die. I wish to end my life with dignity, surrounded by my loved ones, whilst I'm able to breathe on my own, speak, and in circumstances where I am surrounded by my loved ones, I'm able to see them, hear them, feel them, and be aware of their presence. Justices of the court then proceeded to grant the relief based on what it found to have been intractable suffering to which the late Strachan Ford had been subjected to. Of course, we know now, based on the evidence of Dr. Cameron, that he did not have to go through that fear that he harbored at the time of approaching the court, because he died exactly as he sought to die, in dignity, namely surrounded by his loved ones, whilst he was able to, all the matters that he sets out at paragraph 35, we know as a matter of fact that he realized his death wish. So the question, what we submit emerges from this, is that at a subjective level, he was never subjected to the indignity of dying in pain as he thought he would be.
Yes, so we understand that the factual foundation simply wasn't there. But what if a court is faced with a case where the factual foundation is clear, that there is no palliative care available, that the patient is going to die an undignified death?
Well, that then takes us, Justice, when we leave the subjective analysis and we deal with it objectively, in other words, we posit the question whether the impugned common law rule can reasonably impact on people in that manner, then the answer that we proffer is that no, for the simple reason that there is, on the evidence before you, palliative care has been shown scientifically to deal with 90% to 100% of the pain suffered not only by cancer patients, but by people who are suffering from the so-called intractable pain. So on that basis, there is no justification. It cannot be said in our submission that the common law rule, viewed objectively, has that impact.
Well, let us take a patient who is suffering great pain and who doesn't want the kind of palliative care that is on offer. Is it not that patient's right to choose how she dies?
We submit that is and we rely for this proposition that we are about to make on the judgment of the Carter, referring to the court of court, where a lot of evidence was led, where the judge in the court of court says clearly, and we agree with that analysis, that the right to life does not entail the right not to live. And that really is the constitutional architecture within which we wish to locate our argument as regards the right to die.
What about dignity and self-autonomy, which is a part of dignity?
Self-autonomy creates a slight difficulty for us on the judgment of Pretty. But whereas we accept self-autonomy, we submit that on the circumstances of this case and having regard to the potential, to the implications of legalization of euthanasia, the limitation to self-autonomy is justifiable.
I'm concerned about this. It's the second time you've referred to the legalization of euthanasia. Mr. Strachan-Ford's case is based upon the fact that he was suffering from terminal cancer of an aggressive form, and he did not wish to suffer what he regarded as the indignity of living out his last period on this earth in extreme pain, subject to opioids and other treatments and the rest of it. And that's what he regarded as a breach of his right to dignity. Now, that is a different case. That's the same case as, in fact, Ms. Seals advanced in the New Zealand court. That's a different case from, for example, Nicholson, where Nicholson was a case of euthanasia. He wanted, in fact, somebody to either set up the machinery, which then by an eye-blink computer he would activate, which would inject him with a lethal substance, or actually to just do the injection themselves. Now that is euthanasia. That's a different kind of physician-assisted death from the circumstances we're talking about. And there are other cases where people are looking, people who have ALS, the people in Ms. Purdy's situation, or Pretty's situation, who want to live as long as possible, but they realize that they will get to a stage when they can no longer commit suicide, and they will need physical assistance to do so. And Mr. Strangton-Ford wasn't in that situation. His situation was never, I will not physically be able to commit suicide. His situation was, I want the means to commit suicide when I decide that my painful existence is intolerable to me. Now, why are we not confining ourselves to arguments about the fact of this case rather than some general proposition about euthanasia? Why don't we wait for that case to arrive, for someone to bring an application like Ms. Pretty or Ms. Purdy or Mr. Nicholson?
The word euthanasia, as we use it in argument, we use it to denote two scenarios, and those are the scenarios postulated in the notice of motion. The first one being the PAD, so-called physician-administered
Assisted death.
Physician-assisted death.
death. Well, I'll leave death on the side. The two concepts that I would like to deal with. The one is physician-assisted euthanasia, or physician-administered, rather, euthanasia, PAE. And what that, on the one hand, has in mind is a doctor with a strange Dr. Kevorkian scenario injecting.
But was the respondent in this matter asking for that?
As we read the notice of motion, yes, because it's in the alternative. Is provide me the means or do it.
Yes, but the point I'm putting to you is he didn't make a case that he needed physically the assistance of a doctor to commit suicide. What he wanted was the means to do it himself. That is, he wanted the prescription for a lethal agent. That's the second alternative. In essence, what I'm putting to you is the first alternative in the prayer had no factual founding whatsoever.
Yes.
And that should be set aside on the basis there was no, that wasn't a proper case before the court. That must be dealt with if and when that case arises.
I'm with you. I'm with the justice.
What we're concerned with is physician-assisted suicide and the entitlement to ask, whilst competent, to ask a doctor to prescribe drugs that you can ingest at your own time and in your own circumstances that will have the effect of enabling you to commit suicide. That is the factual problem in this case, and it's the only factual problem.
We submit in that regard, as regards the assisted suicide in that context of being given the pills and going to Cape Town and to surrounded by family at glass of wine doing it. In that scenario, justice, the factual foundation for that is equally non-existent because he says that.
No, I understand you say the factual foundation, but I'm putting to you that that's actually the case he tried to make. That's the case he tried to make. Whether he made it is another matter. And the reason I'm putting it to you is I don't understand why we are being asked, as it were, to deal broadly across the whole spectrum of potential euthanasia, physician-administered dying, physician-assisted dying, the ability to, and a whole lot of other things which didn't arise in this case. Why are we being asked to deal with that?
Except he's asking for physician-assisted.
Well, he asks for both.
He asks for both.
he asks for both, and if I understood Justice Wallace postulates that in relation to euthanasia, the administration with a syringe, he did not make out a proper case for that because he has not alleged disability of the sort in Pretty Rodriguez and the other case, Carter, I think, as well. So if we then leave the euthanasia proper analysis, we leave it out of consideration on the basis that he's not disabled, and we focus only on physician-assisted.
These circumstances, the case he made on his affidavit, leave aside what the notice of motion, the case he made on the affidavit, let's focus on that.
Sure. With respect, the case he made on the papers is a case that says that, doctor, help me, terminate my life, kill me, murder me, intentionally terminate my life by giving me a lethal injection.
Why do you say that's criminal? Why do you say it's murder? What's your authority?
The authority for the proposition that such a scenario leads to murder. It's, I think, such cases as Fort John, and there's another case that came about after Fort John, remembering, and we'll find them there in volume 3.
That's not what John says. That's my problem. The judge in his judgment in paragraph 13, you'll find in volume 6 at page 873. He says the current legal position is that assisted suicide or active voluntary euthanasia is unlawful. And he cites De Belloc, Marengo, and Grotjo. Now, De Belloc was, like Hartman, a case where the accused actually actively killed him. It was a mother who drowned her hopelessly handicapped child and a very, very desperate circumstance. Marengo was similar. A caregiver, a daughter, father dying in great pain of cancer, suffering from Alzheimer's, and at night she took the gun he had next to his bed and shot him. Now, that's not this case. Grotjon is a wholly different case. In Grotjon, Mr. Grotjon and his wife had a furious row. The marriage was on the rocks. She was bipolar and partially paralyzed. And in this row, she says, I'm going to shoot myself. So he walks out of the room, finds a bullet in the flat, comes back, loads the gun in front of her, having just repaired it and removed the trigger guard, and hands it to her and says, well, shoot yourself then, you're nothing but a burden. He said it in Afrikaans, but that's effectively what he said. And she did shoot herself. Now, that's totally different from a patient who's suffering enormous pain, goes to their doctor, says, I can't stand this. I want a prescription that will enable me. When I've decided the end is there to terminate my life, take the case of Brittany Maynard in Oregon. That's exactly what she did. She got the prescription and she penciled into her diary for the 1st of November. Had her family round, went for a long walk with the dogs, climbed the hill, came back and took the drugs. The doctor was 6 months away from it. Now, Grotjon doesn't speak to that situation. It says the question is one of intention. The question is one of whether the suicide act is a novus actus interveniens. Now, the whole case starts from this proposition of law, which is simply wrong on the judgment. So, should we look at the law as it is? That's what the Constitutional Court said in Mighty Solutions.
We submit, Justice Wallace, that Procedural and indeed Hibbert, those cases, the effect of those cases is to visit criminality, an act of criminality to someone who assists in suicide. What happened after Procedural, which the justice has dealt with, in a lengthy fashion, the courts had occasion to deal with a similar matter in State versus Hibbert, and that judgment is referred to by the...
In fact, they're almost identical to Grotjon.
But Hibbert, where the court there found that if you provide the means to an individual to end their life, knowing that they're going to so end their life, you're culpable criminally. So this is the basis on which, among others, we submit that provision of medication in those circumstances.
What I'm putting to you is that the whole basis upon which this case has been argued involves a clear misreading and misunderstanding of what was said in Grotjon, very carefully, about the influence of intention, causation, and the intervening act of the suicide in committing suicide.
We are aware of the other judgments like Gordon and Bakwa, which were to...
Those are different things. Failed suicide. Bakwa on Grotjon is probably a case where there should be a conviction. But none of them are dealing with this situation. The doctor, out of reasons of compassion, provides a prescription to a dying patient that they may take, if they choose, at a later stage, when they believe their life has become intolerable. Where in Grotjon does it say, well, that is criminal? It says nothing more than, in some circumstances, encouraging, assisting, providing the means may be criminal.
That's as far as it goes. We accept that. Now, we will step off that point and
I didn't quite get the submission on the questions posed by my sister presiding regarding the assertion the suggestion before of his right
to pay that I'm subjected to because of my disease. He says in the passages that I referred to earlier, Justice Dambuza, that there is no dignity in dying with your body being in pain. That's the first thing he says. When there's a machine, be it a ventilator, he calls it a machine, unclear the type of machine he had in mind, but having a machine attached to your body, being hospitalized. So he describes to the court what he means by an undignified death. But key to that definition is the intractable pain. Now, perhaps I should direct the court's attention with respect to the definition suggested by the South African Law Reform Commission of intractable pain. Intractable pain, according to the South African Law Reform Commission, and this suggestion they make, having conducted extensive...
As a matter of first instance, for argument's sake, if we assume that his anticipated death and the pain that he anticipated were true, was indeed what he would suffer, does he have that right to accept that individual right to dignity of choosing the way to end his life? To end his life.
And if I may, I'll be allowed to challenge the assumption, because the assumption that he was going to suffer intractable pain, that is the unfounded assumption.
I think you're at cross purposes with Judge Dambuza. What she is putting to you is assuming those facts were correct, assuming that what Mr. Strachan-Ford said could be substantiated, would he not have the right to determine his own manner of death and when he died?
Well, based on human dignity.
Yes.
If the assumption is that he suffered from the intractable pain and bringing into it the personal autonomy, then one might be hard-pressed to say that there is a justification to the limitation of the right judging by the implications that would flow from allowing such a scenario to prevail.
So in a proper case, and your submission is that this is not a proper case, in a proper case, a court might be required to protect dignity and self-autonomy by recognizing that there should be a choice.
Well, we say a court would find itself having to limit that supposed
But that's another issue.
entitlement
The
based
question of what safeguards one puts in place and what limits one places. But that's an entirely different issue and another very fraught factual problem.
That's right. We deal with the implications of what I call legalization, and I use legalization having taken into account what has been said in that regard. But the implications, the broader societal implications of that legalization, justices, we deal with those in our supplementary heads. And we submit that based on those factors that we have enumerated in our written supplementary submissions, the court should, even in a proper case, limit such a right if it were to be found to exist at all. So I have had to deal with my submissions in a manner that's different from the way one had planned to, but most of the issues would appear to me. How much time do I have still from inquiry?
You have 15 minutes.
15 minutes. Thanks, Justice.
Perhaps you want to address us on the question of the separation of powers and whether a court is able to decide for society that there should be a right to die in dignity.
We have dealt with that issue rather in a lengthy manner in our notice of appeal.
Yes.
And we stand by those grounds supported by the authorities that we put up in the notice of appeal. Rather unusual procedure, but that's what we have done. And those are our submissions in that regard. What we start off at paragraph 11.1 on page 954 of volume 6. Paragraph 11.1, we quote from the judgment of the Court of Law, where His Lordship Mr. Justice himself made the concession, if one were to call it that the ideal course would have been for the legislature to consider this topic. And we agree with the learned judge that there was no reason why for him to stampede himself in the manner in which he sought to do, especially that given the premature demise, as it were, of Mr. Strachan Ford.
Wasn't there more a case of the pace at which the litigation was conducted rather than anything else? Can a court refuse to decide whether there has been an infringement of a protected right on the basis of separation of powers issues that we think it would be a good idea for Parliament to deal with this? Surely that may have something to do with justification, or it may have something to do with remedy, but it can't surely have anything to do with whether the right has been breached. That's a matter for courts.
How we deal with this issue, and I'm delighted that the issue has been raised. We accept that in terms of Section 39(2) of the Constitution, if a court such as this, a court sitting such as His Lordship Mr. Justice Fabricius was sitting, finds that a common law rule is repugnant, then in terms of 39(2), a court is enjoined. In fact, a court is obliged to develop the common law rule accordingly. That's the point that we made in our supplementary heads. We made that point with reference to the Mighty Solutions judgment, which we have quoted in there, paragraph 38, where the Constitutional Court set out a whole systematic approach to. So we accept that as a proposition, and we're saying we've subjected that judgment to that analysis in our supplementary heads. And if it might help the court for us to take a step back and go back there, we're happy to do that. But we've dealt with it, we'll submit fully in our supplementary. So yes, when a court finds itself confronted with a common law rule that is repugnant, a court has to act accordingly. We say in that regard, however, that this rule, the rule here, is not repugnant for the reasons that we set out in our supplementary heads of argument. Courts have done so. The Constitutional Court refused to develop the indubitable rule. There's a separate, I'll deal with that. But the court in tables refused to develop the doctrine of common purpose, and the court usefully has told us what steps, how a court should approach such a question. The Constitutional Court, in yet another case, decided to reverse, I think it was the Only rule by His Lordship, Mr. Justice of Appeal Zulman, as it then was. The Constitutional Court found itself confronted with a repugnancy of a common law rule, and it acted accordingly. So we are by no means suggesting that a court confronted by a common law rule that's repugnant should simply say, no, it's a matter for the legislature. That's not what we are submitting. But we're submitting that analysis has to take place. And if one were to conduct that analysis, the 38A Mighty Solutions analysis on the facts of this case, it doesn't take His Lordship Mr. Fabricius home. That's our submission. As far as, in other words, it doesn't need Justice Wallace with respect to it doesn't justify the conclusion arrived at by the protocol of developing the common law in the manner in which it's sought to do. So now going back, if one may, to the separation of powers, we deal with it. 954 is that the ideal course. We agree with what Justice Fabricius said. There was no basis for him to find a repugnancy that entitled him to invoke 39(2) in the circumstances of that matter. He should have deferred to the legislature, and we referred to the relevant case law at page 955 of volume 6, cases such as Camichel, the certification judgment, where what's been emphasized is that the major engine for law reform is Parliament, and courts should, in a proper case, defer accordingly. This case we submit, justices, raises emotive matters, of a polycentric nature, goes to allocation of resources. If the rule were to be, if euthanasia were to be legalized, matters such as safeguards, in other words, Parliament has to determine what safeguards ought to be put in place, how are those safeguards to be enforced, how are they going to be monitored. All those matters we submit are matters of a polycentric nature that require a deference with respect to the legislature. So we rely on what we have stated in the notice of appeal, supplemented to the extent necessary by written submissions. That then, unless justices would like us to deal with any further matter, that those would be our submissions, and we'll deal with the further issues that arise in reply.
Thank you.
May it please Justice Wallace and Justice Wilson.
Thank you. You will, of course, have the opportunity to reply if necessary. Yes, Mr. van Bergen, are you or Mr. D'Oliveira arguing first?
May it please you, Justice Lewis, I am ready to proceed.
Yes.
As I indicated to Justice Lewis in chambers, there has been a separation of labour in our camp, with me addressing the factual issues and my learned junior, Mr. D'Oliveira, addressing the constitutional arguments. If I
Yes,
may,
would you like to come to the podium? Perhaps counsel could take a moment to move.
Perhaps your junior should move at the
Yes.
same time so that he's at least accessible.
Yes, please.
Thank you. If I may commence, Justice Lewis and Honourable Justices, by addressing what our learned friend for the first, second and third appellants raised, and that is the issue of mootness. The abridged time periods within which the deceased brought his application and within which it was heard effectively precluded the then respondents and amici to prepare a proper defence, to do the necessary research, to procure the necessary witnesses, to enable them to present full facts and authorities to His Lordship Mr. Fabricius, to put him in a position to adequately assess all the divergent interests that are at play in a matter of this nature. It was argued before His Lordship Mr. Fabricius that the manner in which the application was brought and in which he had indicated it was to be heard offended the principle raised in a party and another versus Minister of Home Affairs in another, namely that it is not desirable that issues of such considerable importance and complexity be determined in haste. And I submit to this Honourable Court that the difficulty that not only His Lordship Mr. Justice Fabricius was faced with, but also this Court, is that the manner in which the issue was raised and presented was flawed from the outset, and it has spilled over into this Court as well. And it has placed this Court, with respect, at a disadvantage.
Well, we don't have an assessment of any of the evidence. We haven't been able to test it. And as I said to counsel for the first three appellants, there is a plethora of evidence before us, most of which is controvertible.
As Justice Lewis pleases, that is indeed the case. The parties, specifically the appellants, did their utmost to procure credible and weighty evidence to present to this Court. But it can never have the same weight, the same value that viva voce evidence has, as was in the Carter situation. As regards the fact that the late Mr. Stranson Ford passed away prior to His Lordship Mr. Fabricius issuing the order on 30 April 2015, I, then for the third respondent, the Health Professions Council of South Africa, raised the issue of mootness with Mr. Fabricius before he gave his judgment on 4 May 2015, and I requested that he recall his order on the basis of mootness. And I relied on the provisions of Uniform Rule 15.1, that no proceedings shall terminate solely by reason of the death, marriage, or other change of status of any party thereto, unless the cause of such proceedings is thereby extinguished. And clearly, as has already been argued before this court, Mr. Stranson Ford's personal rights ended when he passed away. And that made an end to the matter, and that is supported by Makwanyane, paragraph 26 specifically, and also ex parte Masimi Rembwe, N.O. It is not on our list of authorities, and I apologize to the court, it is 1995-1 ZLR 144H at 148. And why I specifically raised it with Mr. Justice Fabricius at that time was that I had been at pains during argument before him that if he was inclined to grant the relief sought, as became clear at an early stage he was inclined to do, that it go no further than the applicant himself, and that it not set a general rule. And when I asked him to rescind, recall the order, he declined to do so on the basis that the judgment and the matter had wider societal interest.
Sorry, are you saying that he was in fact asked to recall the order after you learnt of Mr. Stranson Ford's death?
Indeed, Mr.
And he
Justice.
refused to do so.
I beg your pardon?
And he refused to do so.
He refused to do so.
On the basis that it had broad societal implications,
As the court
which he
pleases.
thought he could determine in a matter of a few days,
As
sitting alone.
the court pleases.
Sorry, when was the actual argument? Was it the 28th or the 29th of April, or did it flow over both days?
The argument, and I'm speaking under correction, if I may just verify with my learned junior. The argument was on the 29th of April, and the order was on the 30th, which was a Thursday. The intervening Friday and Monday, if I recall correctly, were public holidays, and the Tuesday, if I recall correctly, was the 4th of May, and that was when the judgment was given.
I suppose his view that his order had wider implications comes through in his approach in the judgment, because the judgment is in general terms rather than confined to the case that is brought before him.
That is indeed so, Justice Mbuza. And that was why it was of concern to me, on behalf of my client, the Health Professions Council, because the assurance had been given that it would go no further than the case of Mr. Stranson Ford, personally.
Mr. Converting, what was the response of the applicant in the court below to your request that an order be rescinded because the matter had become new?
Justice Skippers, I can't recall the exact argument, but it was opposed. And I submit to the court that on that basis alone, the relief that this court ought to award is to set the order aside and to dismiss the application.
The
When
appeal.
you say it was opposed, was there some argument or some formal representations made by more than your party?
I raised the issue. There wasn't a formal application. I raised it from the bar because we had only over the weekend become aware that he passed away. And if I recall correctly, the then first, second, and fourth respondents, now the first, second, and third appellants, supported the application. I do not recall the attitude of the amici, but the respondent opposed the application.
So it will be on level.
Well, it was argued. So the argument, if the argument was recorded, it should be on record.
Was it argued in the same court in which the judgment was handed down?
It was indeed
Before the judgment?
before the judgment was given.
judgment doesn't, unless I actually mentioned restraints and force, yes?
It makes no mention what it refers obliquely, Justice Wallace. It says, and I can't recall, it's early in the judgment. In parentheses, it says he passed away on the day that I gave judgment. If I may just lay my hand on it.
I don't know. Sorry, it's in paragraph 3. I've got it.
As the court. That is the first point that I wish to make, is that the matter had become moot and it should have been recalled on the 4th of May, 2015.
We did have our reasons for the order, and we are now faced with those reasons, and I presume you don't want them to stand.
Indeed, that is why I wish to address the court, because of the principle of precedent. This order and this judgment stands as it is, and we have to deal with it. And for that reason,
It's been considered both in Canada and in New Zealand.
it has. It's referred to in seals, as Justice Lewis pleases. And for that reason, we can't limit our argument purely to the issue of mootness and lack of factual foundation. And we have to look at the more substantive issues, the constitutional arguments, and as I've indicated, my learned junior, Mr. De Oliveira, will address those issues. As far as the facts underlying the application of the late Mr. Stanson Ford are concerned, he made a variety of allegations which I think to the ordinary reader would have been quite horrific, and which clearly made an impact on His Lordship, Mr. Justice Fabricius. Allegations about extreme pain, about dissociated or becoming dissociative because of medication, that this would would increase and more progressive, and that he would ultimately die a terrible death. The fourth appellant at the time had not had the opportunity to investigate these allegations. Subsequent to the order being given, consent was sought from the respondent, from the executor through the respondent's attorneys of record, to allow the fourth appellant access to Dr. Cameron Bruce, who was the late Mr. Stanson Ford's treating palliative care doctor. That consent was refused.
Mr. Van Bergen, you can accept that, speaking for myself, that those facts are all known and that this court ultimately issued an order. What I would like to hear on simply is that what is your submission that have the facts as they appear from Dr. David Cameron's affidavit, the subsequent information, even before the court below, what is your submission to the outcome of the application?
Mr. Justice Scribbers, before His Lordship, Mr. Fabricius, let me rephrase that. My argument would have been, before His Lordship, Mr. Fabricius, that there wasn't a sufficient, that the argument put forward by the late Mr. Stanson Ford, that physician-assisted suicide was the only medium through which he could protect his dignity in his terminal condition, was incorrect. The information obtained by Dr. Cameron, who was commissioned by the fourth appellant and not, as was erroneously indicated, by the first, second, and third appellants, the information he obtained from Dr. Bruce clearly shows that the palliative care that Mr. Stanson Ford received was efficacious. It controlled his pain at relatively low doses of morphine. The morphine dosages, if I recall correctly, were a maximum of 45 milligrams per day, save, I think, during the last 2 days, when it went up to 75 milligrams. And in Dr. Cameron's initial affidavit, he indicated that palliative care regularly gives up to 100 milligrams of morphine per day. So Mr. Stranson-Ford never reached the point where the higher dosage was required.
Finally, at this point, what do you say? What's your submission, Mr. Van Bergen, in relation to the one incident where it was expressed to Dr. Bruce that there was a misgiving about whether to proceed with physician assisted care?
Mr. Smithers, that is, I submit, a very important and a very relevant aspect which will be elaborated on by Learner Jr., because it indicates that the late Mr. Stranson-Ford did not have a settled intention of bringing about his end by means of physician-assisted suicide, whether through a toxic substance that was provided to him by a medical practitioner or whether by the medical practitioner administering such a toxic substance. And it indicates that, as was mentioned earlier, that there was vacillation on his part. And that ties in also with another important aspect that arises from the further information. Mr. Stranson-Ford was assessed on a single occasion by a clinical psychologist, Ms. Melnick, on 10 April 2015. And on the basis of the single consultation, she found that he was competent to come to the decision that he had, and as was set out in his application. If one has regard to the additional evidence submitted by the fourth appellant, that of Dr. Henk Swanepoel, a clinical psychologist, and Dr. Eugene Olish, a psychiatrist, both of them and also some of the other experts mention that depression and anxiety are conditions which are commonly found in patients suffering from terminal illness. And they further say that it is extremely difficult to make a diagnosis of depression and anxiety, but more so the effect on competency. Dr. Swanepoel mentions that it can take up to 12 weeks and numerous consultations before a proper assessment can be made. And that raises the question whether His Lordship Mr. Fabricius's finding that the late Mr. Stranson-Ford had been competent was in fact based on solid ground.
But it was certainly not based on evidence, proper evidence.
Indeed.
It's a very, very unfortunate aspect of the way in which the application was run.
As the court pleases. And that is a central...
The very, very scanty affidavit of Valentine's knowing is really nothing, and it wasn't.
As the court pleases. And that is the central theme to this court, is no matter from which side one approaches the case, as it was before His Lordship Mr. Justice Fabricius, there was just a failure to obtain sufficient, credible, weighty evidence that was required to address a subject as grave and as important as physician-assisted suicide.
All of this goes to the manner in which the litigation is conducted. Would you put to you a difference? Is there any difference in principle between someone coming to the court and saying, I think my death is imminent, I'm in extreme pain, it's going to get worse, I think I'll be hospitalized, and I find all that very undignified. In other words, the sort of cases Stranson-Ford tried to make and didn't make on the affidavit. Is there any real difference between that case and the person who comes to court and says, as, for example, Ms. Seals did in the New Zealand case? I'm a 45-year-old practicing attorney, happy family life, and so on and so forth. I have been diagnosed, and I have, a brain tumor that is going to kill me in the next 6 months. I'm already suffering the symptoms. I'm having such treatment and palliative care as enabling me to continue the moment of my life. But what I want is the ability to say to my doctor, provide me with the means when I conclude that my life is intolerable. And I'm no longer really the person I've always wanted to be and that I've always been. Provide me with the means that I may then say my farewells to friends and family and commit suicide. But is there a difference in principle between that case and the person who comes along somewhat later in the progression of the disease and says, really, I need it up because I might be dead in 2 weeks. She died, I think, 2 months after the judgment, Justice.
Mrs. Wallace, if I understand your question correctly, my answer would be there is no real difference in principle. The relief sought is the same.
And the implications to the law also.
They are indeed. And it goes, I would submit, once again, the central theme here is intent and causation. What is the...
Address the argument on the law, accepting and the seal as a potential act, first on substantial fraud and all the deficiencies of the record.
Well, it has to be assessed on 2 legs. The first would be the facts, obviously, and to see whether the facts make out a proper case to commence with. And then secondly would be the substantive issues, the constitutional issues, whether in fact rights such as dignity, bodily integrity, and so forth are affected. And as I indicated, Mr. De Oliveira will address those issues. My submission to the court is that purely on the basis on which the application was brought and was heard, this court ought to set the order aside, and that should be the end of the matter. But it has to, I submit, the other issues ought to be heard as well, in light of the fact that there is a judgment that needs to be addressed.
Are you ready to hand over now to Mr. Oliveira?
I have just one final point to make, Justice Lewis, and that goes to costs. I would submit that the principle in the BioWatch matter should apply in this case, save insofar as the costs incurred by the fourth appellant in obtaining the further evidence through Dr. Cameron. And that is an issue that, in terms of the court order issued by this court, was reserved for adjudication by this court. And I submit, for the reasons set out in that application, that it would be appropriate for the respondent to pay those costs. Unless there's anything else the court wishes to hear from me, I would then hand over to Mr. De Oliveira.
It may be convenient to take the short tea adjournment now.
So danke Musi.
Mnandi siyiwe ye manje. Amanga wala manje apho.
fall anymore. Basically somewhere in 2. Sicela ungifakele
Yes, Mr. D'Oliveira.
Justice Lewis, I propose to divide my submissions this morning into two sections. The first section will deal with the approach that the HPCSA has on the scope of right, the constitutional argument in relation to the scope of the right to dignity and freedom and security of the person. And the second section of my argument, I propose to deal briefly with factual matters which underlie the justifications argument.
Well, Mr. D'Oliveira, seeing Mr. van Bergen didn't deal with it, I'll have to ask you. When are you going to deal with the true import of Grotjohn's case? Which everybody has assumed says one thing which it doesn't say. Not on my reading of it, anyway.
Yes, Justice Lewis, on our reading...
That's Justice Lewis.
Justice Wallace. Justice Wallace, on our reading of Grotjohn, the act of enabling another to commit suicide, we appreciate that the facts in Grotjohn were different in that there was an immediacy between the handing over of the gun and the act. There was no great separation in time. But what the elements was, there was no separation in time there, in contradistinction to the factual scenario that Justice Wallace, you raised earlier, where you posited the situation where a doctor enables a patient to end his or her life by providing a lethal substance, and then that patient, a month later or a few months later, takes a walk, says goodbye, and does it. We say, the HPCSA says that there is in law no difference.
Well,
and the reason...
let me just read you the relevant passage from the judgment, and forgive my pronunciation. Die gevolgtrekking kan kwalijk vermy word dat hy wat die gesogte of nodige middel vir 'n voorgenome selfmoord verskaf 'n oorsaaklike deel daaraan het as dit uitgevoer word. And then the critical passage. En as hy dit willens en wetens doen met die vereiste opset dat 'n eind gemaak word aan die lewe van die persoon wat selfmoord wil pleeg, dan is hy skuldig aan moord. But it's very clear. The judgment dealt with causation, which is what the basis upon which the High Court had acquitted Mr. Grotjohn. And it's the basis upon which Mr. Justice Henning acquitted the accused in Gordon. And all the court said is, the fact that there is an act by the suicide after the action of the person who encourages them, provides them with the means, and helps them, doesn't break the chain of causation. But what the judgment also goes on to make clear in other passages is that the chain of causation can be broken by the independent act of the suicide, where that is clearly a separate and distinct act from the action of the person who assists them. And the other elements still have to be satisfied, that there must be willens en wetens doen met die vereiste opset, dat 'n eind gemaak word aan die lewe van die persoon wat selfmoord wil pleeg. Well, in the scenario I painted to you, I don't see where that kind of criminal intention arises.
With respect to Justice Wallace, the HPCSA respectfully disagrees, because the doctor that provides medication, lethal medication to a patient in circumstances where the patient requests that medication for the purpose of ending his or her life, does so knowing that that individual is going to, and foreseeing that that individual is going to use that
foreseeing
means.
That they may use those means. The evidence of the state of Oregon, put up I think by Cowles, says that of 155 prescriptions that were issued, 55 were not used. And there is similar evidence, as I recall it, from the Netherlands and Belgium. Mr. Justice Steyn is absolutely clear. Ook die aanmoediger of helper sou na gelang van die omstandighede van die besondere geval. So it depends upon the circumstances. We're not dealing with the doctor prescribing drugs at the patient's request. We're not dealing with the person who loads a firearm and hands it to their spouse and says, well, if you want to kill yourself, go ahead and do it. Which is what happened in Grotjohn and what happened in Hibbert.
Justice Wallace, as I understand it, what the court is saying to me is that on at least Justice Wallace's reading of that judgment, the law as it stands enables is either undecided or it is permissible for a doctor to provide a patient with lethal medication.
And in a criminal trial on that point now, the court would have to look at the law as laid down in Grotjohn in the light of the obligations under the Constitution and in the light of Section 39(2) of the Constitution, wouldn't it?
Yes.
So if my reading is a fair reading, then one gets to constitutional questions as to whether in those circumstances the delicate question of intention is discharged by a prosecution. And let me just add this. I'm sorry if I'm talking too much, but let me just add this. That is the law of Switzerland, Article 115 of its criminal code. That is the basis upon which the Supreme Court in Montana held that there was no guilt. I think it's the same effect in the Supreme Court of New Mexico. They have consistently said that there is no guilty intention. And that's also the basis of the judgment of the Colombian Supreme Court, that the doctor in those circumstances does not have a criminal intention. Now, why are we operating on the basis that a doctor would necessarily have a criminal intention in this situation?
Mr. Justice Wallace, you cited from me judgments of courts and laws of countries which are permissive in this area.
No, those are the judgments which lead to that. No. Switzerland is a matter of the criminal code, but the other three are constructions of their criminal law and the concept of intention.
Yes, and at least, although I don't have the authority in front of me, but as I understand the judgment of Nicholson to read, at least the United Kingdom's Supreme Court and the law in the United Kingdom is different.
Yeah, but that's because there's a statutory provision in the 1961 Suicide Act which specifically criminalizes any assistance, irrespective of intention, to assist a suicide.
Well, whatever the reading of Grotjon may be, it's not for us to determine the issue, given that it simply isn't before us on the facts.
Yes, and Justice Lewis, as I understand it, the invitation of the court prior to the adjournment was for the argument to proceed on the assumption that we need to deal with the issue that is raised.
Yes, yes, but we're not faced with the situation where a doctor gives a prescription for medication which may lead to fatality. It's just not before us, is it?
It's only before us to the extent that the order made by the court quo contemplates such.
Yes, except that it's so vague that it would be very hard to determine.
Justice Lewis, if I might just preface my submission with respect to the scope of argument in this context, saying precisely this. Justice Wallace, as well as the court, has raised, as the court generally has raised, concerns about essentially what could be characterized as the ripeness of this issue, and especially in the case of the magnitude of the importance that this is. I submit that the approach that the court should adopt is an approach that is appropriately tempered with judicial restraint, not inviting, not addressing these issues until they are ripe. Yes. Because, Mrs. Justice Lewis, whilst the Constitution does mandate that courts must deal with issues when the violation of a right under the Constitution is raised, and essentially the circumstances are such that it is bound to do so. In this case, we are the opposite of that. This court does not have to deal with the issues and make final determinations for the law of South Africa on these issues. And the approach, in this instance, the approach that was adopted by the United Kingdom Supreme Court in Nicholson, I would submit, is the correct approach. There was a great deal of evidence which was placed before that court. I would submit much more than is before this court. And yet, the court in that instance was deferential. It said the judges gave views on the issues, but indicated that the nature of the matter, that in the circumstance of the matter, that they should be deferent and first allow Parliament to deal with the matter, and only if it failed to, and only if they were compelled to, and I think several of the judgments mentioned, and only in circumstances where there was viva voce evidence and proper cross-examination on the underlying facts, would the court then seize of the matter itself.
Yes, the difference between the UK position and ours is that the matter has been thoroughly debated in the UK Parliament, and private members' bills brought before the House of Lords proposing some form of legalized euthanasia or physician-assisted suicide have been debated endlessly, and that Parliament has not concluded that this is a matter that can be determined. And the courts, the UK Supreme Court in Nicholson, as I understood, were deferential to the fact that it was being debated. Here, it hasn't been to Parliament, and it's not likely to get there anytime soon. So how do we protect the right to dignity and self-autonomy in an appropriate case?
Justice Lewis, in this circumstance, the HPCSA submits that since the court is not called upon to develop the law in this instance and on these facts, the court, for that reason, should refrain from doing so. If the court were to wish to grapple with and to provide indications of the fact that the law might require development here, then the court might do so, except the HPCSA submits it shouldn't, because it's not...
And not a proper case to do so.
Yes, but with that in mind, might I then move to my argument on the scope of the right to dignity, because the HPCSA submits that at the very least the court should exercise restraint also, because it is not certainly not a fait accompli that the right to dignity demands that an individual be entitled to be assisted by a doctor to commit suicide. And on that note, I think as I understand the debate before the court, essentially the question is, should the law allow medical doctors to enable patients to commit suicide as a matter of constitutional entitlement? And the HPCSA submits that as the Constitution does not, in the first instance, afford individuals that right. Now, it's in a matter such as this that the philosophical underpinnings and approach to the interpretation of the Constitution comes to the fore. I think it is State versus Mlungu. It's one of the earlier decisions of the Constitutional Court and it's a decision by Justice Kentridge. It might be Zuma. Justice Kentridge said that the Constitution doesn't mean what we wish it to mean.
That's in Zuma.
Yeah, as it please, Justice Wallace. And the court would no doubt have noticed that before the court there are two competing interpretations of the right to dignity under the Constitution. The one is the one adopted by the applicant in the quota quo, which places primacy on the right to autonomy. It in fact interprets the right to autonomy with the right to dignity with the right to autonomy at its fulcrum. And
it's a subjective approach.
It is a subjective approach, Justice Skippers, but I think it is perhaps it fits more neatly within the context or placed in the context of, or the category of the approach of Justice Ackerman in Ferreira versus Levine, where there was this conception of the Constitution giving freedom, although he combined it with dignity, but a negative freedom, that the individual has this expansive freedom. The individual is entitled to under the Constitution as a matter of entitlement, to do what he or she wants or likes, and every single incursion on or limitation on that right has to be strictly justified.
Yeah, but without taking you out of the side of your argument, Mr. De Oliveira, there is, of course, the competing right to life. And in the Hungarian case, it was held that the right to dignity is not unrestricted when you're dealing with the competing right to life.
Yes. Justice Skippers, and that's precisely where I'm going. Whereas the applicant would argue for this expansive interpretation of dignity that places autonomy at its fulcrum, the HPCSA submits that under the Constitution of South Africa, the position is not so, and that is because, and as been stated by the court, our Constitution puts into place an objective normative value system. In other words, it's an objective order of values. It's not what I say it is. It is, or the individual asserts it is. The question is, what is that objective order of values? And the answer to that question is that that objective order of values can only be gleaned or discerned by properly interpreting the Constitution, beginning first with the text, then interpreting it within the context of the Constitution as a whole, as well as our history. And essentially the steps that the HPCSA submits that this process of interpretation involves runs briefly summarized as follows. The HPCSA submits that human dignity under the Constitution is inherent human dignity, which of course incorporates the right to autonomy. That is an incident of human dignity, but that autonomy is not an expansive autonomy. The Constitution itself contemplates that there are certain things which might not bring any harm to anyone else except for the person, which the Constitution doesn't sanction. The example within the text of the Constitution itself is the prohibition on the right to slavery. Whilst in the
prohibition on slavery.
Prohibition of slavery. Apologize, Justice Lewis. It's my first appearance in the SCA, and I will blame all my blunders on that, as it pleases the court. The point is that in Barkhuizen versus Napier, the Constitutional Court affirmed that the right to autonomy entitles a person even to contract to their detriment in a particular context. But we know that that right to contract to your detriment doesn't extend absolutely, because I cannot, or a person under the Constitution cannot claim a right to sell him or herself into slavery for a year. And why? Because the Constitution, which is premised on the right to dignity, says that human beings can never be made objects of or commodified. The same reasoning underlay the Constitutional Court's rejection of the autonomy aspect of the right to dignity in the sex workers case. The Constitutional Court said that there's no right that can be asserted that you're entitled to have sex which is paid for in private, because that is in conflict with the values of the Constitution, and particularly it objectifies the human person. Now, we submit that similarly, the right to autonomy is limited by, in particular, the right to equality and the right to life in the Constitution. Limited not in the justification sense, but limited in the scope of right sense. In regards to the right of equality, South Africa's history is one and the right to dignity springing forth from South Africa, the South African context, is one in which there were lines drawn between those who were worthy and those who were unworthy, those who had dignity and those who didn't, on the basis, in that instance, of race. The Constitution also mentions expressly the ground of disability. And it guarantees that the equal dignity of persons of disability. Now,
But it's not a criminal offence for someone to commit suicide or to attempt to commit suicide. So, people situated as Mr. Strachan Ford was situated, they can commit suicide. What he's really asking for is to be able to do it in a fashion which doesn't involve undue pain or distress to relatives or any of the awful means which people do sometimes adopt to commit suicide. So seeing that they are entitled without adverse legal consequence to commit suicide, why is their dignity not affected by being compelled to choose an unpleasant, unsatisfactory way of doing that instead of a peaceful one assisted by modern drugs?
Justice Wallace, the reason is there is a distinction which needs to be drawn, I submit, in this context, between the legally protected entitlement to do something, in this instance, commit suicide, and the decision of the law as a matter of policy not to punish persons who do so. As a matter of policy, in our law, persons who commit suicide are no longer criminally liable.
They can't be.
Because they can't be. They also can't be held criminally liable for assisted suicide. Justice.
For attempted suicide.
Attempted suicide, Justice Lewis. But that is because the origin, as well as the resolution or the solution to the problem of suicide, so recognized the law, doesn't lie within the field of the law. But that is different. That is different from the scenario. Just because I can do something as a matter of fact doesn't mean that I have a legally protected right to do so. And the Constitution itself doesn't ground, at least it hasn't been interpreted thus far, and it shouldn't be interpreted to ground a legally protected constitutional right to commit suicide. Now, to complete what I was saying concerning equality, the equality must be, the right to dignity must also take into account the right to equality. And if the law starts dividing society up again by saying, well, persons within a certain category, in other words, if you're suffering, or if you have a mental or physical disability such that you're incontinent or you lie spastic on the bed, and I've seen persons like this, the law doesn't permit, and the Constitution doesn't permit, a line to be drawn saying, well, this is undignified. And
isn't that inequality in some way justifiable? It's not an irrational or arbitrary distinction.
No, Justice Lewis, it's certainly a differentiation can be made, but the equality jurisprudence, as I understand it, judges whether that differentiation is permissible or not with reference to the impact on dignity. And the impact on dignity, if I assert that, well, this incontinence or this inability to wash myself and this which I'm suffering, which many people do, this is undignified. I, as a matter of constitutional right, it should be recognized that my claim that this is undignified is correct, or legal entitlement or legal recognition should be given to it. Then the implication of that for the dignity of persons who, by virtue of defect or accident, are in those circumstances, is that it infringes upon their dignity.
But the problem is, we've got to deal with this in terms of our Constitution. All the cases we've looked at overseas are under different instruments with different provisions. They get to dignity by other routes. We've got Section 10. Every person has inherent dignity and the right to have their dignity respected and protected. Not some generalized concept of dignity. Everyone's entitled to have their dignity respected. So the person who is lying in a persistent vegetative state, their dignity must be protected by the way in which they're treated and so on and so forth. Now, why does that not apply to everybody else? Their dignity on matters intimately connected with their own life and the process, the last stages of life before death draws down the curtain. Why is it not their dignity that matters, instead of some generalized concept? What's it got to do with equality?
Justice Wallace, I'm trying to follow your argument, but I cannot find precisely the clause of the Constitution you rely on.
It's not an argument, it's a question.
I mean, the question.
Well, let me try and clarify for you.
Justice Wallace,
Okay.
the question. I just want to specifically read the particular provision of the Constitution you're referring to. Justice Hollis, I found it. Apologies, I was looking in the equality clause. Justice Wallace, I don't, the HBCSA doesn't necessarily understand, or it's not a necessary reading of Section 10 to divorce their dignity from the context in which the context of the right to the reference to inherent dignity at the beginning of the sentence. Everyone has inherent dignity and the right to have their dignity respected and protected. The HBCSA submits that their dignity, which is referred to there, is not the subjective conception of the individual of his or her dignity, but it refers to the inherent dignity which is guaranteed and protected under the Section 10.
Well, the cases in the Constitutional Court derive the notion of personal autonomy from this provision. It's a personal autonomy. Now, just take an example. Assume my brother Skippers and I are both diagnosed with the same dread disease. We may cope with it totally differently. I may wish, for one reason, to terminate my life when pain becomes too much, when I think the effect of palliative care will be bad. He may take the view that that actually is a good thing in society, and dealing with pain and suffering is actually a good example and beneficial to society. So we're not interested. Well, why isn't respecting our respective dignities, in his case respecting his dignity in deciding he doesn't want to do this, in my case respecting my dignity in deciding you do want to do this? Why isn't that what the Constitution says? Dignity must be personal. It's not some impersonal concept. It's a personal concept.
At the same time, Justice Wallace, I go back to where at least the HPCSA's argument started. How then is the interpreter of the Constitution? Let me rephrase, Justice Wallace. What limit does one place to on the individual's conception of subjective dignity? Then I can assert, as the example which is given in the HPCSA's heads of argument. I'm somebody who's very rich. I fall from grace. I'm bankrupt. I now live in squalor. I have no dignity. I want to, on that basis, end my life. In that instance, I submit that the Constitution, whilst the law as a matter of fact doesn't prevent the person from committing suicide, as a matter of constitutionally protected rights and entitlements, the right to that claim by that individual is not constitutionally protected, I submit. And the question, the key question, which is the court in this instance, or the court ultimately with the proper factual foundation before it, must answer, is whether the claim by the individual that is faced by suffering, says that this is undignified, I want to end my life, whether that is a properly constitutionally grounded claim.
Isn't there a matter for justification for the constraints that are put in place to protect vulnerable people? I may say that, because again in my reading of the foreign legislation, in some jurisdictions, in that circumstance, you would be perfectly entitled to commit suicide with assistance. I think in the Netherlands, where profound depression and so on is accepted as a reason to commit suicide. But it wouldn't be accepted in the state of Oregon or Washington, or even under the Canadian legislation. Isn't it a matter for the justification rather than the infringement?
And sorry, before you respond to that, just to add to what my colleague is saying, I thought actually that was the argument by HPCA, because in from paragraph 42 of HPCA's heads, the meaning of the right to dignity is set up, and there seems to be an express recognition of the right to dignity. And you say the right to dignity requires us to acknowledge the value and worth of all individuals and members of society. And then from there,
is placing emphasis on the fact that when the Constitution protects the right to dignity, it doesn't protect the right to dignity of the individual in isolation, who may assert a particular subjective conception of the right to dignity. It is the Constitution protects the dignity of all. And in that context, when somebody makes a claim under the right to dignity to say, well, X and Y and Z is an offence to my right to dignity, such as...
Aren't you rolling the two arguments into one? I mean, the two rights, the two dignity assertions into one? The elementary right to dignity that all individuals possess, and the justified implication.
With respect, Justice Dambuza, we're not. What we're saying is that dignity properly construed, and if you construe it, for instance, also within the context of prohibition of slavery, the Equality Clause, as well as the unqualified right to life, that within its scope, it does not contain the right to die. It doesn't contain a right to commit suicide, a legally protected right to commit suicide, as a matter of scope argument. And if that argument is incorrect or held not to be satisfactory or a correct interpretation of the Constitution, and it is found that the right to dignity does encompass within it an autonomous right to commit suicide in certain circumstances, it is then that we move to the justifications argument and say that the blanket prohibition within the South African context is nevertheless justified. I hope I addressed your question, Justice Dambuza.
Perhaps then you could move to the justifiable limitations.
Justice Lewis, you gave an indication at the outset of proceedings that that much of the evidence, or in fact you said all of the evidence, the new evidence, is not in...
I said that you could argue as if.
Yes, but not is not incontrovertible.
Yes.
But Justice Lewis, I want to limit my submissions in relation to justifications, factual submissions in relation to justifications, to four factual elements which I submit are not controverted in the evidence in front of you, and are arguably not controvertible. The first is, I wish to remind the Court of the vulnerable which the law prohibiting murder and prohibiting assisted suicide protects. And the particular reference which I wish to provide the Court is to the report of Swanepoel, which is on page 274 in volume 2 of the HPCSA's a new evidence application. Justice Lewis, what courts might lose sight of is precisely what it means when we say the law is there to protect the vulnerable. Who are these vulnerable persons? At page 273 and 274 of the opinion, Dr. Swanepoel sets out the psychological landscape of persons such as these. And at the top of the page, 274, he says, first, after reviewing many studies concerning how these individuals feel themselves a burden on others, arising from their depression and their suffering, he says, having regard to the results of the studies referred to above, and given their vulnerable physiological and psychological state, there is a real danger that persons who do not want to die will nevertheless choose to die because they will feel obliged to choose PAS. The risk is also high that family members, relatives, or members of the community may also successfully, overtly, or covertly pressurize persons into requesting PAS. Patients in this condition are in fact so emotionally and psychologically vulnerable that some may feel obliged to request death, whether the aforesaid external pressures exist or not. And then lower on the page, in the second paragraph, there's a passage that sentence that begins with the hopelessness that people in this context experience. Hopelessness leads to feelings of isolation and is a good predictor of suicidal ideation among patients nearing death. This suggests that the patient has a lack of sense of meaning or purpose. Like self-deprecations, patients who feel life no longer has intrinsic meaning or purpose will not intuit that others view them as still having value, in spite of advancing disease and increasing dependency. They're simply unable to intuit that they have any value. This perception of needing to take while having a little to provide in return further clarifies the psychological landscape to the sense of burden to others. If patients, and a few lines down, if patients experience their very lives as lacking value or worth, they are unlikely to perceive that others will ascribe these same attributes to their current continued existence. The significance of this evidence in the context of justifications is really twofold. The first is that there is a very real and recognized risk that individuals, if the law allows the prescription of lethal medication or euthanasia, that individuals in this state will feel, because of their psychological condition, will feel themselves burdened to choose it, even if they don't want to. And that is because they are unable, because of their condition, to intuit that they have any value, and they sense themselves a burden. And it's to protect individuals in this, and sometimes that is the pressures, etc., are internalized. So you have a person who presents himself as saying, I want to commit suicide. This is what I want to do. But actually it's because they feel they're a burden. They have no ability to feel themselves of any worth or any value unless they are given alternative help. And
Mr. Oliveira,
yes.
As I read the cases, there seems to be a common thread that there's no less restrictive alternative, that you cannot narrowly tailor an exception to cater for this category of vulnerability. That comes both from Nicholson as well as from the New Zealand case. Did I misread it?
I submit that we read the cases the same way, and we make an additional submission with respect to the psychological suffering of those people who are out there, who never come and present themselves before a doctor, but who, knowing that there is this option out there, will spend the rest of their days in anguish. Well, I want to live, but should I not rather stop being a burden to others? And they will experience a form of psychological suffering, which will be inflicted on them, as it were, by the existence of this choice in law. And there's nothing except a blanket prohibition which can prevent that.
Mr. D'Oliveira, I don't want to rush you, but you have already exceeded time. I wonder if you could just deal very briefly with the other three factors that you say go to justifiable limitation.
I shall. Justice Lewis, if I might just then provide three references. The first reference is to Maiza, the social worker, Mrs. Maiza. It's on page 260 to 262 of the HPCSA new evidence application. The second reference is to Dr. Boer on page 303, and I'll tell you the content. I'll just summarize briefly the submission. And the third reference is to page 333 of the HPCSA's new evidence. The first, going back to Mrs. And that is concerning Oregon and policy. Firstly, in relation to Mrs. Maiza. Mrs. Maiza is a social worker who has provided social work to persons in this scenario, both in rural Natal as well as in Soweto. And she provides a very lucid account of how the community, how the people deal with suffering, and how they deal with it in a manner which the community gathers around the person suffering. Some people even give up their jobs so that they can look after the particular person. And that this is a culture, this is the way that this suffering is that the person who's facing terminal illness is looked after. And how if the law allows physician-assisted suicide, this will be a threat to this, a very real threat to this culture, because it will provide a legitimate excuse for the family to say, oh, well, we can, instead of Gogo filling the bed, or Gogo taking the very little money we have, we can now legitimately say, well, Gogo, you must shuffle along. You must take this choice. And this will erode a culture where the dignity of these individuals is upheld. And that is not a culture which we submit the Constitution sanctions. Secondly, in relation to Dr. Boer, although replying evidence was provided by Kells, what is telling is what was not refuted. At page 303, Dr. Boer says that there were in 2012 there were an estimated 280 cases where the persons were euthanized without their consent. In 2001 and 2005, he provides the percentages and the references. The numbers were greater. Now, if that is what happens in a first world context, where there is not an imbalance of education and there is not an inadequacy of policing and criminal justice as there is in the struggling South African context, how can South Africa conscionably contemplate providing assisted suicide here? And then the last point, Justice Lewis, concerns assisted suicide and money being a driver of policy. Also, what was not refuted was the evidence provided that was the evidence provided by Dr. Stevens that in Omaha, medical aids will now pay for assisted suicide, in Oregon, medical aids will now pay for assisted suicide, but they won't pay for treatment. Once again, in the South African context, the government and medical aids need no encouragement in that line to start to cut back on providing proper treatment to people who need it, on the basis that there is this assisted suicide is available. And to allow assisted suicide in that context would also be unconscionable, and the provision should stand. That is the reason why the blanket prohibition remains justifiable. Those are my submissions.
Thank you. Mr. Moran.
As it pleases the court. Justice Lewis, would it be appropriate for me to start with the question of mootness?
Well, you could explain how it is that the court was not advised of death, and what the attitude of the court was when it was explained to it that the order had become moot.
The matter was argued on a day, I believe it was a Wednesday. At the end of the day, His Lordship, Mr. Justice Fabricius, concluded that he was going to give an order. The matter stood down for purposes of getting an instruction from the state as to whether there was an aspect of the order to which they would consent. The next morning, Mr. Stranson Ford passed away, and His Lordship made an order at a time when he was unaware of the fact that Mr. Stranson Ford had passed away. The legal team also was unaware of that fact. In fact, on the first day, that is the Wednesday, I was involved. The next day, I was at a funeral. But on that day, or during the course of that day, my learned friend, Mr. van Bergen, phoned me. He apparently knew about the possibility that Mr. Stranson Ford had passed away even before I did, and I then made inquiries and found out that it, in fact, had happened. But at that point, Mr. Justice Fabricius had already made the order. As had been indicated, there was then a weekend, and after the weekend, His Lordship was then going to deliver a judgment. It is true, he was informed of the fact that the applicant had passed away. And again, I wasn't there, but my learned friend, juniors were there. And I've been told that they did oppose the fact that he didn't deliver the order. And
I'm sorry, I didn't hear that. They did oppose the fact
that the order not be recalled.
Mr. Murray, did you have any instruction, or the question that you haven't answered is, was there an instruction to the attorney that Mr. Stranson Ford had passed away at 8:07? Was there such an instruction?
Yeah, the attorneys were advised of that fact, but not when it happened.
But that's the question by my sister presiding.
Yes, the position is that Mr. Stranson Ford passed away, and then at some time later, she wasn't a widow anymore, it was his ex-wife, who was there when it happened, advised the attorneys and counsel that it had happened. But at that point...
Well, it took her some time to advise the doctor, did it not?
Yes, it did. Now
and the first thing she said to the doctor after having told him that her former husband had died was he won his case. Quite an extraordinary situation.
Yes, I don't know how she knew that. There are a variety of things that we don't know about.
It raises another problem, Mr. Maria, which is, do you mind telling me who you represent here?
Today?
Yes, today.
Yes, the estate of...
What claim has the estate got? As I put to Ms. Nkosi Thomas at the beginning, isn't this the clearest possible example of a delectus personae, a claim that is not transmissible after the death of the person who makes the claim?
You see, at the time, and also now, our submission is that in terms of Section 38D of the Constitution, we remain in a position where we have an interest in this matter.
38D?
38D.
What interest?
Was this claim brought in the founding affidavit on the basis that the applicant is acting for all persons similarly situated?
No.
But then Section 38 doesn't apply.
You didn't go to court saying you were acting in the public interest?
Yes, no, we didn't.
And in Nicklinson's case, when Mr. Nicklinson died, his wife became an applicant, and a further person became an applicant, and the court specifically said that, in fact, Mrs. Nicklinson had no standing to raise breaches of the Section 8 of the Convention. He said it wasn't her right.
Yes, no, that is the only basis upon which we submit to
Well, it's not the basis upon which you proceeded, and I don't see how it can be called in aid now. The fact is that there is no respondent.
The submission I was going to make is that is the basis upon which I submit that we are here. If the court concludes that on the basis that, by reason of the fact that the order was not sought on the basis of Section 38, well, then I have to go.
Let me be blunt, Mr. Maria. Is the estate, in fact, instructing you? Is it the estate that is instructing you, or is it some NGO that has an interest in this case?
Mr. Justice Wallace, my belief is, or my view is that I'm instructed by the estate.
Well, there is an NGO referred to in the papers.
That is so.
Who claim on their website that this is their appeal.
Not aware of that.
Yes. And they're seeking to raise funds for that purpose.
They are also not aware of that.
No, well, they are, because I saw this, so I went to the website to see who this organisation was, and there they are saying that they're bringing an appeal to the Supreme Court of Appeal, and they're auctioning a cartoon by some cartoonist signed by Archbishop Tutu, and asking people to provide funds. Now, this is profoundly troubling, because if the NGO has an interest, then like other NGOs who have been here, it could have intervened and so on. But it's profoundly troubling not to know who, in fact, the litigant is.
Well, I'm not aware that I'm acting for an NGO.
But you believe you're acting for an estate.
I do.
And there's no right that inheres in the estate in this regard.
Well, unless if Section 38 is in the past, then that conclusion is correct.
Yes. What do you want to?
How does practically?
Well, practically, it is an interest which the deceased had. He passed away, and it remains a matter then of public interest also to him to pursue the matter. The question then is whether I'm going to be permitted to continue addressing the court.
Well, you may address us. You've heard our questions to the appellants, but we would ask you to confine your submissions merely to the principles upon which the Judge Arquo thought he could decide.
My submission would have been that the idiosyncratic circumstances of that matter are unimportant, but if is the question, are those the facts that I should deal with, because I intended to deal with the relevance of the judgment now that it has been given, and to deal with that briefly. And that is having regard to the order that was made and the implication of the judgment, whether I would be permitted to make submissions in that regard.
Yes, you may do so briefly.
Yes, I'm indebted. In our submission, any person has a variety of rights: the right to life, the right to dignity, and the right to self-determination, the right to autonomy. And for purposes of the submissions that I will make briefly, I will be referring to those simply as the rights of self-determination. That is, that any person has the right to decide or make important decisions relating to his own life, also relating to his death. And there, by and large, I agree with my learned friend, Mr. de Oliveira, that there are certain rights which a party may make or a person may make affecting his own life, which he would not be allowed to make in his own interest. And those would then be, as an example that was given, to consent to be sold into slavery. It is possible that a person may not sell his kidney to raise money to buy a car. And there are instances, therefore, where even though a person has a right to self-determination, that right will be limited in the protection of that person. On the other hand,
protection of other people.
Yes, that's the next leg. That's the first leg, to protect himself. The second leg is also to protect other people.
Is the state under an obligation by virtue of the provisions of Section 7(2), read with Section 11 of the Constitution, to protect vulnerable people from being induced, persuaded, put it how you like, to commit suicide. Is it under an obligation to protect them, and by virtue of the right to life?
Yes, the submission that we make is that it is a weighing up of those interests, and that would be that a person would be entitled to choose euthanasia, but it is important, and it can't be, or other people's interests cannot be ignored, and it would then be necessary to protect their interests as well.
Assuming, Mr. Murray, contrary to what I've put to two of your colleagues, that the effect of Grosjean's case is to criminalise any assistance in regard to suicide or any encouragement to commit a suicide. Assume that. Why do you say that that is not a permissible response in the circumstances of South Africa to the obligation of the state to protect the life of the vulnerable?
Our submission is that in circumstances where assisted suicide is required, and on this premise that would involve that circumstance, it would then be necessary to approach a court and to obtain an order under a judicial supervision permitting that person to an assisted suicide, which would have the effect in our submission that the weak and the vulnerable will be protected against harm in that way. Very much the way that was suggested as a solution by Lady Hale and Lord Kerr in the Nicholson.
They were clearly influenced by Carter's case and the approach the Canadians took to it, where they said a blanket prohibition would be overbroad in accordance with Canadian jurisprudence. But the majority in the Supreme Court did not think that under the European Convention that a blanket prohibition in those terms was not within the legitimate margin of appreciation of a country, and it was something that Parliament could do. In other words, they said it wasn't overbroad. It met the proportionality requirements of the European Convention. Why in South Africa is that prohibition overbroad?
Well, in our submission, certain of the other lords in the Nicholson matter were, in principle, prepared to make the order, save that it was thought that it was preferable.
In the right case?
Yes, I accept that. Yes, in the right case. But thought that it was better that Parliament dealt with it. But they themselves weren't necessarily of the view that the order could not have been given. In fact, Lord Wilson indicates that Parliament should deal with it, and if Parliament didn't, then the court would do it afresh, and went so far as indirectly to predict what the outcome would be.
Would he change sides and join with Lady Hale and Lord Kerr?
Yes,
that's what he indicated.
But our submission is that the approach in Carter's matter was correct, and then also the approach by Lady Hale and Lord Kerr, and that therefore a prohibition against, or a blanket prohibition against a PAS would be overbroad, and that if one were to involve judicial oversight.
Why is the view of one Irishman in the form of Lord Kerr to be preferred to the view of the full Irish Supreme Court, which reached the contrary conclusion, applying the same directives?
Simply on the basis of the cogency of the argument. And obviously this court is not bound by anything that any of those justices...
Well, it's a very different situation. In that particular case, the court was looking at its own statute and determining whether
a provision was compliant with the European Convention on Human Rights. We are not so constrained, but we are constrained by the fact that courts should not step into the terrain of policy making. And policy making is inevitable when you're dealing with an ethical and a moral principle. On what basis is the court able to determine for the public what their moral and ethical rights and obligations are?
In that regard, we have two submissions to make. In the first instance is, at least on the face of it, there's an infringement of a constitutional right and the infringement of the correct person determining or making a determination in respect of the manner in which he is to die. But added to that...
Can I just understand, that's on the basis that the right to dignity includes the right to control the manner in which you live, and that will include controlling both the manner in which you die and when and in what circumstances that occurs. That's the contention.
Yes, that is so.
The case, if you don't make it on dignity, you're not going to get there on any of the other rights that are peripherally mentioned. Is that correct?
Well,
well, he mentions bodily integrity in his affidavit.
Yes, all those things could be interpreted as a feature of the right to dignity.
No, but if you don't get home on the main argument about dignity, you're not going to get home on one of the lesser.
Yes, I can see that. But in circumstances where, if the court finds that in these circumstances the prohibition against assisted suicide in South Africa is overbroad, and it may be necessary to deal with Grotjohn's matter anyway, but if it's overbroad, then we're in a situation where two things have happened. And the one is that there's been a report by the Law Commission dealing with this, which is something like 15 or 17 years old, and it has never received attention. The state doesn't seem to have a willingness to deal with this, and Parliament has never looked at it.
Well, the state says we have other priorities.
Yes,
so it's very unlikely that Parliament is ever going to get to this particular issue. But isn't it properly run for Parliament after public comment and participation in the debate?
Well, that would be the ideal situation, but that is not what is happening. And as indicated, the state's attitude is we have other priorities. That doesn't mean we are necessarily against it. It is just that it hasn't come up. It's still down on our to-do list. We intend doing it. We intend going to Parliament with it. But
well, hang on, the minister's here today, yes, opposing any change in the law.
Yes, no, that's the next part, and that is that in paragraph 134 of my opponent's heads of argument acting on behalf of the state, it is indicated that why bother the state? If you have a problem, commit suicide. It's not like you don't have a remedy. There's a way out. Just follow it. The position, therefore, is that, in fact, the way that matters stand at the moment, the state is opposing it, and the state is against it. And the state's not going to do anything about it. So whilst it may be a good idea that Parliament does something about it, unless the court does something about it, no one's going to do it.
Do we not construe the state's attitude as being that it is content with the law as laid down in Grotjohn, as it has been put to us, leave my reservations aside, and they think that's how the law should stay, full stop? That's why they're not dealing with it.
Well, as you've indicated, Justice Wallace, there's a general misconception in respect of the interpretation of Grotjohn's matter, and the question whether, in the case of an assisted suicide, is considered to be a crime, and it is likely that a doctor who assists in that way will be prosecuted. Along with that, there is the attitude of the Health and Health Professionals Council that it is unethical behavior, therefore that it shouldn't happen. Which is why, ultimately, or initially, when the application was brought to, which came before His Lordship, Mr. Justice Fabricius, a part of the order that was sought at the time was to direct or to declare that the doctor who performed the assistance, and in that regard, the order in fact said either by providing the material or by administering it. It actually deals with both those elements. But ultimately, that the doctor who did that would, one, not act or would not commit a crime, and secondly, would not act unethically. Now, the position at the moment is, or at that point was, that if a doctor were to have assisted by giving a medication to a patient who then took it 6 months later, it is likely that that doctor would have been prosecuted. Now, at the same time, that doctor would have been able to rely on Grodjohn's case and make the distinction and point out to them, the judge hearing the matter what you've indicated, Justice Wallace, and may even then be able to be acquitted. But what is clear is the state would have prosecuted. And what is also clear is that the council would have taken the attitude that the conduct was unethical. Now, Strantham Ford or any other person in his position, or the right person for purposes of our argument, would not be able to find a doctor to assist him by giving him the medication, even if that was lawful.
We don't even know on the papers whether there was such a doctor.
We don't, but we're not dealing with respect with this specific matter, but generally, and that is the position that faced any doctor who was engaged by the right person to assist him in or her for purposes of his or her suicide.
No, the doctor could do exactly what the doctor did in Carter's case. Because one of the applicants in Carter was a doctor, to say, join in proceedings with the patient, saying, this is my patient, the patient wishes to do this, I am willing, on grounds of compassion and proper care of the patient, to assist them in this fashion, and then the case is properly raised. They can then debate whether in fact they would be guilty of a crime. The court could then develop Grotjohn, could do what the Montana court did or the Colombian court did. They could do anything.
That certainly would have been an alternative. But ultimately, what had to be done is to obtain a decision by the court, whoever brought the application and whoever the parties were, to in fact determine the actual and correct interpretation of Grotjohn's case, and to be certain that in circumstances where the physician provided the prescription, that the doctor would not have been committing an offence or acting unethically.
It seems to me that all the considerations that you've raised are all pointers to the fact that the court is inappropriate, is the inappropriate forum to determine this case.
No, in my submission, the point is quite the opposite, and that is that it is as possible that Parliament would be the better institution, but Parliament's not doing anything about it. In Carter's matter, the court then said, well, at least made a declaration of what the legal position was, at least indicating that the prohibition was overbroad, and left it to Parliament to do something about it.
Yes, but the difference in Carter's case is that it was done pursuant to wide-ranging evidence from ethicists and physicians, and in a case like this with an organization like the HPCSA, because conceivably it may happen that the majority or 90% of doctors in this country might refuse to administer or to provide lethal substances for physician-assisted death. And that evidence obviously would have to be evidence, not opinions expressed in affidavits, because that would have to be tested in the court. That's what happened in the case of Carter. The appeal court was in a different position because it could consider the evidence of the court below. So it's not a question simply of this court, without more, giving effect to the constitutional rights. It's going to involve a very complex and copious process. Do you accept that?
I have two submissions to make. The one relates to the attitude that was taken in that regard by Lady Hale and Lord Kerr, where they were inclined to make the order without considering all the evidence, and where they conceded that or indicated that this is a heated debate where there would always be people pro and against it.
All the more reason for a court not to make a decision. A heated debate, very, very controversial issue, questions of public morality and ethics.
I made the concession that it is better for Parliament to do that. The only question is, and that's the only submission that I have to make, is that in circumstances where Parliament's not doing anything, whether it is not necessary for the court then to do something to make it possible. And whilst it's not suggested that that is the ideal route, in our submission that ultimately is the only route. We also submit that as far as the evidence is, which is before the court at the moment, whether it's evidence or however it is seen, but on the basis of what is before the court, we still submit that in circumstances where there is a proper judicial oversight, as envisaged by Lady Hale, in circumstances to determine whether we are dealing with the right person, that is the person who really fits.
So there has to be judicial oversight in the case of every person who wishes to take this route?
Well, that would be necessary until Parliament has something else about it. But there ultimately can't be another way.
It's going to be an extraordinary burden to the justice system, to the court system, if there are indeed people who wish to be assisted with their suicide, if they have to institute actions because applications are just not good enough, institute actions to be given the right to an assisted death.
Well, the fact that it creates work in itself is not a reason why it ought not to be done. But on the other hand, what is...
well, there are other priorities.
Well,
there are competing rights.
Well, in circumstances...
In a very, very badly strained judicial system.
Well, if our opponents are to be understood, most people are happy with palliative care and would not seek the necessity to bring proceedings of this kind. But it is not, or it's very difficult, if at all, to determine what number of people in South Africa would be interested to follow this. For purposes even of evidence in respect of what would be necessary to do to protect the weak and the vulnerable. In fact, it is possible that if the matter goes to Parliament and Parliament then deals with the matter, may come to the conclusion that the procedure that would be followed, well, that it would be allowed, but the procedure to be followed is a judicial oversight. So ultimately, that always remains a possibility. And in fact, ultimately, it is the best solution. It's the best way of determining having today would be unnecessary. And in fact, it may actually be go very far to remedy the situation. But that is not something that the state has done, and it is possible that this court would be in a position to provide certainty as far as that goes.
I wonder if you could wind up your argument.
I've made the submissions that I need to make, so unless there's anything else that I need to address the court.
Can I just ask you one question, Mr. Murray? Do you concede that, in the light of the facts of this case, that the order by the court below was inappropriate?
I don't make the concession.
You don't.
I'm not sure. Thank you, Mr. Moran. Yes. Thank you, Ms. Engelbrecht. Would you try and complete your argument before 1?
Absolutely. Mr. Marais confronts the singular question when he is asked about Grootjan. Because what the questions about Grootjan point out quite clearly is that here there is another person involved in the death of the person seeking it. It is not simply somebody acting on their own. There is another person for whom there might be consequences. And it is precisely that point that we must bear in mind when we think about the construction of the dignity right in the context of this matter. When we say there is a right to dignity that is enshrined in our Constitution, we must accept, as we do with all other rights, that there is a corollary to that right, and that is an obligation. It is an obligation to give effect to that right. We would submit to you that the logical conclusion to be drawn from the submission that there is a right to dignity that can only be saved by the assistance of the intervention of a medical practitioner, then the corollary of that is, well, then it is an obligation on a medical practitioner to provide that assistance when it is sought.
Well, it is there. That's a different question. Merely because a person may have the right to require assistance doesn't mean that any doctor, every doctor, is obliged to afford it.
Yes, well, the question is precisely this: to what extent then is the doctor entitled to say no, as it were?
Well, that would be determined by Section 8.2 of the Constitution.
Correct, because that...
it's the nature of the right and the nature of any duty imposed by the right. Yes. And if the nature of the right is to have assistance from a willing medical practitioner, then there's no duty imposed upon an unwilling medical practitioner.
But that requires the reading in of the willing practitioner. So in other words, there must be a reading in to say that when I ask to be assisted in suicide, then there must be a doctor who is able, despite the infringement, the alleged infringement on my dignity, that doctor must still be able to say, I will not assist. I want to draw the attention of the court, as we did in the heads of argument, and it was referred to earlier by Justice Skippers in passing, but in the Hungarian case, particularly at page 38, where the majority is speaking about specifically the question that exercises the minds of the justices here today, is the right to self-determination, and then where does the limit lie? And in paragraph 4 of the judgment at page 38, the Hungarian court says the desire of a terminally ill patient to have his death induced by a physician, for example, by supplying or administering an appropriate substance. So this is both the cases postulated by His Lordship, Mr. Justice Wallace. So by supplying or administering an appropriate substance is, as indicated by the Constitutional Court, beyond that part of a patient's right to self-determination that is unrestrictable, both in part or in whole by the law, as in such cases, death is actively induced by another person, that is, the physician. Therefore, the possibility of a physician actively inducing the death of a terminally ill patient in the patient's request cannot be deduced from the general right to self-determination enjoyed by all patients. We would urge this court to take into account that particular aspect of the judgment, but the judgment as a whole, particularly in light of, if one reads the seminal judgment about life, State versus Makwanyane, one will see that the Constitutional Court on several occasions, I think there are something like 15 to 20 references to either Hungary or Hungarian. The Hungarian law is relied on in the context of the right to life case. That is the seminal case about the right to life.
There's been a major transformation of the Hungarian court in the 20 years between Makwanyane and now, one which has been extremely controversial and within the European community because the government fired all the judges and started de novo.
My Lord, sorry, Justice, that is true. But what is also true is that there was a certain constitutional equivalence, as it were, that was relied on by the Constitutional Court here when it sought to place reliance on the Hungarian position. And when that constitution is unchanged, we would submit to you that the interpretation of that unchanged constitution, which is very similar in its provisions to ours, that still holds force. We wish to make this point that in South Africa the right to life is truly something that stands centrally. It is, of course, the source of all rights. And we have taken, in light of our history, a very particular view about the protection of life. We have, through State versus Makwanyane, taken a view against state-sanctioned ending of life. And we submit that the granting of the right, especially in these very peculiar circumstances on which I need not address you any further, but the sanctioning of that right to assist in the dying of another person or bring about the dying of another person is something that is carving away at that which stands so centrally, almost wholly in the South African Constitution, which is the right to life.
How is that compatible with the judgment of Justice Tyrion in Clark and Pierce? How is that approach to the right to life compatible with Judge Tyrion's judgment, which is itself has been followed in the House of Lords as it then was and elsewhere?
Justice Wallace, the point is the point that I'm trying to make, and it is the same point that I would say fits in with that particular analysis, is this coexistence of life and dignity. So there is and the Hungarian case we submit does that beautifully, explains the interrelation, that there are moments of coexistence and moments where the one operates to limit the other. And it is for this court then to strike that balance, unfortunately, because it is now faced with, what if the judge gets it wrong? We can't go back. And we say, finally, this one point. The Law Commission report gave 3 options. It didn't simply say that there must be allowance made for physician-assisted suicide. It gave 3 options, and one of the options was to do nothing. It seems to us that that is what the state has followed.
Yes, it was misread, I think, by Judge Fabricius.
Yes. So the state is following the first option, which is no legislative change. And there are, as Justice Lewis recognizes, so many more important and pressing matters.
Well, I said that the minister said there were more important and pressing matters.
Yes. But without belaboring the point, it is so that Justice Fabricius, in his judgment, makes a particular point about the identity of this applicant, who is somebody who's learned and read and who can make these informed decisions. If we say that there is an indignity in dying with pain, then it shouldn't be an indignity that can be resolved only for those who have the means and the perceived intelligence to bring such applications. And that's a segue into equality, on which I won't address you further, but I leave you with the thought. Those are my submissions, unless there are questions.
The court will now take the long adjournment. We shall resume sitting at 2.
Are they still bothered by this thing?
two, 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2